after a sumptuous lunch and a crisp presentation covering so many issues, it's daunting to stand up. I don't want to be the one putting you to sleep. So I'll try and cover this somewhat eclectic subject, which has got a range of issues in the subject itself, through 2 or 3 themes. In the new Companies Act and certain recent developments that have happened, the themes that I'm going to touch upon have been affected. Shareholder agreements are agreements between shareholders who hold shares in a company. The Indian contract law allows you to agree to do or not to do anything with a view to obtaining the assent of another person. That's an offer. An offer, when accepted, is a promise. Every promise and counter promises put together represent an agreement. An agreement enforceable in law is a contract. So some issues have arisen historically about whether contracts governing holding of shares in a company, particularly in a public limited company, are at all enforceable by law, and therefore can those agreements be regarded as contracts. The jury has been out there, different courts have taken different views, different benches of the company law board have taken different views, and some have tended to go towards a view that when shares of a public limited company are freely transferable, any agreement saying I will do nothing with it, or I will not transfer it, or I will not dispose of it without giving you a chance to buy it, is unenforceable. Now that controversy has been put to rest in the new Companies Act. 58(2) effectively says that an agreement governing shareholding between shareholders would effectively be enforceable. That would be a contract. When a law says it would be a contract, it needs to be understood that it's an agreement that's enforceable by law. Now, more recently, SEBI too has played a role in which would have a material impact on such agreements. SEBI has issued a notification because there was a lot of doubt even in SEBI's mind earlier about whether agreements between 2 shareholders in a listed company saying, I will not sell my shares unless I check with you, or I'll sell my shares the minute you ask for it, which are basically put and call options between parties in a shareholders agreement. SEBI's earlier stance was that these were not enforceable because they fall foul of an old notification in the Securities Contract Regulations Act. Now the Securities Contract Regulation Act was there for a different purpose. It was there to regulate speculative activity, and therefore it got into the arena of whether options in securities should be freely permitted or not. Now, if 2 shareholders in a bilateral basis give each other the option to buy or to sell shares from one another, that ought not to be violative. Now there is a notification from SEBI explicitly putting this beyond doubt. So the provision of law now is that contracts for preemption, such as right of first refusal, tag-along rights, etc., whether they are in an agreement or in the Articles of Association, would be fully enforceable. Equally, a put or a call option bilaterally or even if it's multilaterally among parties to an agreement, that would also be enforceable. So therefore, to give an example, when the public sector disinvestment happened, the government of India said those who acquire companies could acquire 26% now, but in future if you want to go up to 51, you can exercise a call option on our shares and we'll give it to you. And that price is embedded in the manner in which the option could be exercised under that contract. Typically what happens is once you've signed a contract and you change your mind and you don't want to adhere to your contract, then you resort to law. Like patriotism is a last resort of the scoundrel, said Bertrand Russell. So law is somewhat like that. When you don't want to honor a contract you sign, you look for whether the contract is legal or illegal. Is it conflicting with the law, and therefore I would have loved to perform, but what do? The law doesn't allow it. It's not a contract. It can't be enforced. So that arena just got changed with these 2 developments. The company law saying that contracts between shareholders about their shareholding will be enforceable, and SEBI saying that put and call options in shareholder agreements would be enforceable. Now, as usual, we are a non-English speaking nation working in English, so very often translation leads to issues, and these issues lead to the need to discuss them in seminars like this. So in doing so, SEBI imposed a few conditions. It basically simply said that the title to the shares should have been held for at least 1 year after the contract is signed. A very simple proposition to say that if you held shares for a year, then exercising an option is logical because you're somebody who's at least held shares for a year. Otherwise, you could have an option agreement every day, and that then veers towards the speculative nature of options, which is the objective of SCRA. So if you held shares for a year, it can't be speculation, therefore SEBI says it's fine, it's enforceable. Two, the price at which the option can be enforced, the option can be exercised, should be in compliance with all laws, cross-border, for example, exchange controls. You know, if money has to go out of India, we have a cap. If money has to come into India, we have a flow. So those norms would have to be met. And there should be an actual delivery. You can't contract in that contract. The right is not a transferable right. The exercise should result in the actual securities changing hands. If that were so, life is fine. Now, while doing this, I gave an example of a public sector disinvestment that was not out of the act. In reality, the government changed its mind after it sold certain public sector companies. And when time came to honor the contract, the then Attorney General gave an opinion saying this is unenforceable, these shareholder agreements are contrary to law, therefore the government will not honor a contract that it signed as a sovereign. And therefore there's been litigation about it. So now when one arm of the government wants to clean up the system, it also wants to protect another arm of the government which has taken a stance. And therefore the notification from SEBI says nothing in this notification will affect or validate any past action. What they mean is nothing would adversely affect or positively validate any past action. You don't use adjectives, but as I said, there's a problem with using English. So advisors are falling over each other now to think about, are you required to rewrite the contracts for them to become enforceable today, and then hold on for a year? Or is it only that exercise which happens prospectively is protected? Are all past contracts therefore not affected and therefore not validated by this notification? Again, if you read regulatory provisions like fiscal statute and read it narrowly with a fair degree of violence to logic and support to the language, you'd get a certain outcome. But if you read regulatory provisions in plain English as a commonsensical person would give it meaning, it would lead to a different outcome. And when you read fiscal statute, if two views are possible, the view in favor of the assessee ought to be taken. Even that's under challenge with the concept of GAR. But as far as regulatory provisions are concerned, if two views are possible, you obviously got to take the view that furthers the objective and suppresses the issue that was sought to be addressed. So to my mind personally, I don't see an issue. But again, when somebody signed a contract, there is an exercise tomorrow, you don't want to honor it, people are going to say, let a court test it. And I'm going to say, therefore, that this notification did not affect contracts signed before, so it did not get signed later. Look at the rest of society, many people signed later, re-signed later, therefore I'll not honor. This will happen, there will be litigation, but conceptually, things have changed. And these agreements will be enforceable. There's a capacity, therefore, to get into complex, mature, bilateral, big boy agreements which deal with shareholding. Because if you have a right to own a property, the right to throw it in the Arabian Sea is yours. The right to deal with it in the manner you choose is yours. So these provisions essentially say that if you have a right to freely transferable shares, you also have a right to say, my ability to freely transfer can be fettered by me for consideration, right? So that's become valid now. So that's one aspect of the theme that I have been asked to speak about. To move on to the next aspect is about the implications for MNCs and wholly owned subsidiaries. And I thought, again, as a theme, related party transactions, which the earlier speaker has covered in really nice, crisp detail, is something to watch out for. The Companies Act essentially says that related party contracts, if not in the ordinary course and not on an arm's length basis, would need to be taken to shareholders for approval. And in that shareholder approval, the shareholder who's interested in it should not be voting. special resolution, but the shareholder who is interested in it should not be voting, and the shareholder should approve it by a special resolution. Now, this is something that is going to change the way we as a society have been used to looking at related party contracts. The cheese has moved. We'll need to really, every related party contract will necessitate, and again, there's another provision which says that the audit committee, one of its specified statutory mandates is to approve and say that related party contracts may indeed be, the specific related party contract may indeed be executed. So the onus is shifted to basically put your hand up at the board meeting and say, yes, I know this is a related party contract, but I certify that this is an arm's length and I certify that this is in the ordinary course. You will need to have to put up your hand and say that if you do not want to go to shareholders for approval. If you are unable to say that, you need to go to shareholders for approval. The interested party cannot vote, and therefore, and you will need to pass a special resolution. So if you are a 75% owner, the balance 25%, 75% of that 25% will need to approve that related party contract.